Was Scott Hayes facing an imminent threat of great bodily harm or death such that it would legally justify the use of deadly force?
I think we can kind of lull ourselves into thinking that I've got this particular weapon protect me against this particular event, and if I see something that resembles that event, then I might be more prone towards responding to it with violence.
This is the In Self-Defense Podcast with Don West, Steve Moses, and Shawn Vincent, exploring high-profile self-defense cases and identifying the lessons learned for concealed carriers. Hey everybody, my name's Shawn Vincent. Thanks for joining the podcast today. Today we're going to take you to a little town outside of Boston where back in September, a man named Scott Hayes was at a rally in support of Israel in the Israel-Hamas war. He was attacked by a guy named Caleb Gannon. Gannon ran across the street to tackle Hayes. He knocked him to the ground. Hayes claimed that he was being concussed. He claimed that he was being put into a chokehold. Even though there were a couple people trying to pull Gannon off of him, Hayes decided he needed to use his firearm to end the attack. He shot Gannon non-fatally. Both survived the incident, but in the aftermath, Hayes was arrested. He's been charged with assault with a deadly weapon. It could be up to 10 years in prison. It's a controversial case. A lot of questions about how a guy who was so viciously attacked could be arrested in a self-defense case. It might have something to do with the attacker being unarmed. It might have something to do with the fact that Scott Hayes had posted some aggressive and taunting things on social media that made prosecutors believe that perhaps he was looking for a fight. In our conversation today with CCW Safe's National Trial Counsel Don West and our friend and firearms instructor Steve Moses, we're going to talk about the wisdom of taking a firearm to a demonstration. It's something that if you are a concealed carrier and you have a right to do it, is not illegal to do. It might not be the smartest thing to do. And if you take it, you may be in a position where you'll need to hold yourself to a higher standard than normal before you resort to deadly force. And you may take more efforts to avoid a potential confrontation if you see one brewing. We recorded this a month or two ago. The event was back in September of 2024. I'm recording this now in March of 2025. Hayes has given an interview and he talked about the difficulties that he's had while on bond. He lost his job. He's suffering physical effects from the attack. He can't get employment because anyone just searches his name, sees that he's involved. It's really changed his life. Whether or not the charges are ever dropped or whether he's acquitted at trial, he's already faced extraordinary consequences from his choice to use deadly force in self-defense. We'll get to it. Here's my conversation with Don West and Steve Moses about the Scott Hayes armed defenders dilemma. Sure. And so the case that we're going to talk about is the case of Scott Hayes, 47 years old. He's the defender in this. He's a veteran. He is a pro-Israel demonstrator. So by all accounts, in this little town in Massachusetts, they'd had a number of protests or demonstration. Both there have been pro-Palestinian, pro-Gaza demonstrations. There had been pro-Israel demonstrations. He was staunchly pro-Israel. And not only was he involved in going out and showing his support in these demonstrations, but he also sort of had a lively online life where he would, I think quibble's too kind a word for the kind of jabs and barbing that he was doing with some of the prominent pro-Palestinian demonstrators.
Yeah, he was very visible online on this issue. He made some posts that we would have advised him not to make, I think.
Yes.
if we'd had a
Yes.
chance to do that, and some other personal type aggressive comments that certainly flagged him as someone that people became aware of. And I read some stuff that he was expected to show up, that sometimes when he's going to show up to one of these protests, that the police are even told to expect this guy and to expect him to be armed.
Yeah.
Not that he's breaking the law or routinely committing crimes of any sort, but nonetheless, other protesters are aware of him. They want law enforcement to be aware of it because apparently it's hostile and animated enough that they anticipate there may be some very aggressive behavior.
They felt intimidated by him, I think.
I think that's fair. Sure, he didn't back down. He was a pretty big guy, Iraq War veteran, 47 years old. So he, I think, probably presented a fairly imposing image to most people. Interestingly enough, he wasn't Jewish, but he was adamant there protesting for the pro-Israel contingent. And that's just a cause then that he has, that he decided to be very vocal about and invest time, money, and energy to make his views known.
We talked a little bit about his online behavior during this time, before and after probably. But I got this note here from one of the articles that activists had collected a series of Hayes's social media videos and photographs, and we got videos showing Hayes bumping against demonstrators and verbally accosting him on what I believe are prior occasions to the event that we're going to talk about today. And then you had one that you mentioned, a social media post. Don, do you have that handy? You can tell us what it was.
Yeah, a few months before this incident, he had posted a picture of a 6-hour P365 handgun with an optic and flashlight and sort of all equipped. He had a, a Star of David on a dog tag laid over it, and he was clearly making the post, I think, to demonstrate his support for Israel, but also he had the tagline of the caption on it that said, "Hey, Jew haters, bring it," which you put all that together, it's a pretty aggressive statement, I think. Before we get too deep into the facts of the case and what the self defense claim will be, I do want to point out the stuff we're talking about now may or may not have been known to any of the other protesters that were involved in directly communicating back and forth with him. We don't know if the guy that wound up getting shot knew anything about this guy in particular. He may have, if he's been to other protests. He may have even seen some of these posts. On the other hand, he could be completely unaware of that. And that could ultimately enter into whether the judge lets some of this evidence in, if it's otherwise admissible. And it gets pretty complicated and pretty layered when you start examining prior social media posts, maybe events that occurred after the fact, and sort it all out to see how it impacts a claim of self-defense, which is ultimately what we have here.
Sure. And so let's let our audience in on what happened that makes this a self-defense case, right? So you have Scott Hayes standing on one side of the street. Caleb Gannon is uh, on the other side of this street. There's traffic in the street. Here's a quote from the Middlesex County District Attorney Marion Ryan. She says, "There was a small group of individuals, pro-Israeli demonstrators, who were demonstrating on one side of the street. There was an individual apparently completely randomly walking down the other side of the street." She said, "Words were exchanged back and forth across the street. Um, Ultimately, that individual came very rapidly across the street, tackled one of the demonstrators, that would be Scott Hayes. There was a scuffle that was going on the street, and at some point, Mr. Hayes used the gun and fired a shot that struck the individual who had come across the street. And I think it's important to add that witnesses of it said that Hayes had two other people who are also trying to get this guy off of Hayes, who had tackled him to the ground. and that there's some video in one of the articles I read that showed that immediately after the shot, once the guy's no longer a threat, Hayes told someone to call 911 and started uh, rendering aid.
That's right. Not just remained at the scene, but actually actively tried to render aid and contact the authorities. Yes.
Yeah, and so and before we go into the conversation, we first came across this story in September, and whenever we first see news about a self-defense shooting, we know we don't know all the details. We never actually know all the details. When we get to a point where a case has gone through trial and the trial was mostly public and we have a chance to really get in depth, we can talk a lot more about what we know. But there's always there's always more to the story, right? And some of that information you sent to us this morning about like the social media posts and some of the behaviors that have been reported about him in the meantime. But what one of the supporters who this case is very controversial because if you've seen the video, this guy is clearly angry and charged up, and he darts across traffic straight. If someone was running at you from across the street through traffic and then they jump on you and drag you to the ground, and there's a struggle to get him off. There's a lot of people who are incredulous that this guy was charged in the first place. And one of the supporters, there's actually a protest van with a digital sign on the side of it that had the message, is self-defense illegal in Middlesex County? Scott Hayes, a war veteran, a victim of a vicious attack, was arrested in Newton for defending himself. Scott is facing 10 years in jail. Drop all charges now. Shame on DA Ryan.
Well, of course, we know that there's always more to the story, as you said, but also most folks think that when you can identify who threw the first punch, that you've now solved the problem of who acted in self-defense and who didn't. In this case, it's pretty clear if all you're looking at is the fact this guy ran across the street and tackled Scott Hayes and knocked him to the ground and was wrestling with him, that he was the initial aggressor legally, and he probably was. I don't know what words were said and what invitations or provocation there was for him to cross the street, but looking at his activity, banging into the guy, knocking him to the ground, and clearly trying to control him, that looks like the other fellow is the initial aggressor and that Scott Hayes clearly had the right to defend himself against injury. And of course, one of the questions will be, was he at risk of great bodily harm? Was the threat imminent? And you really just go back to the basics. Was Scott Hayes facing an imminent threat of great bodily harm or death such that it would legally justify the use of deadly force? Because deadly force was employed. Anytime you fire a gun, you've used deadly force, and you're not legally justified to do that unless you're facing that imminent threat of great bodily harm, which in this instance would be, what kind of threat did this counter protester actually pose even after he knocked him to the ground? So that's how you really have to drill into the details to know what was happening on the ground. There was no other weapon, apparently. Was there even, would Scott Hayes say there was a struggle over the gun? That changes the dynamic considerably too, if he saw the gun and was struggling for it. My sense of it, though, is that it may be harder to justify the use of deadly force than it looks like to the casual observer when they see the video. People on Scott Hayes' side said, absolutely, it's self-defense. And the other side is saying, you don't have the right to shoot somebody in that situation.
Steve, is it fair to say that in things like this, you are not a casual observer?
True.
Steve, of course, you're a self-defense and firearms instructor, and you're well-schooled in martial arts. And one of the greatest things that you offer our listeners is your tactical experience. in dealing with use of force issues, right? And so I think if what Don's saying here is that in a lot of ways, this case comes down to, did Caleb Gannon, unarmed, actually, we're talking about ability here, right? Did he actually have the ability to cause great bodily harm and death? And from what you know of this case, what's your take on that?
Well, I would say absolutely he would have the ability. Then the question is did he have the intent and was he trying to exercise that ability? And losing an eye or having people have basically almost gouged other people's eyes out at time, clawed at eyes and stuff such like that. I think that would definitely constitute serious bodily injury. The question was he doing something like that, or is it something that looked more like just a schoolyard fight where one guy's on top of the other and he's trying to hit him, the other guy's covering up? I really don't know. I assume that part of it's going to be, the perception of Hayes. Did he feel like he was in actual imminent danger of being injured in that fashion? And if so, was he aware that other people were trying to pull that guy off? Under the circumstances, I tend to be a little bit skeptical. I'd love to see, a lot more video on what took place. But my first reaction is to kind of stand back a little bit and just say, man, I'd like to have some more facts. But it is plausible that Gannon could have seriously injured Hayes, in my opinion.
Yeah, but I'm glad you brought up that there were two other people who were there, and that we know from witnesses were actively also trying to get this guy off of him. And Don, that makes me think about, I think what a lot of people don't know or realize about the Zimmerman case is that George Zimmerman took a hell of a worse beating for a lot longer than Scott Hayes did, and there was no one else out there in the dark to help him. And the one person who saw him uh, shut the door and ran away when he made eye contact with George. Um,
That's an interesting point, Sean, because it was obvious to George that, notwithstanding the fact he was screaming for help, that's clear, no one was coming to help him, even people that he knew were present. So he was on his own, which I think is a different mindset when you're trying to evaluate the risk that you're facing. In this instance, Hayes knew there were other people with him and would have sensed pretty quickly they were actually trying to help him. There was a claim that Hayes was being choked a little bit. Zimmerman made that claim at one point too. But I think where there's a clear distinction as to why Zimmerman would have felt that he was facing this imminent threat of great bodily harm was that his head was being smacked into the sidewalk. Not that Trayvon Martin had another weapon, but he physically was mounted him. He was on top. He had control, and he was smashing Zimmerman's head onto the back of the sidewalk. And there were two or three clear lacerations and half a dozen goose eggs that corroborated that when he was seen by when seen by the doctor. So it makes sense that Zimmerman, under all of those circumstances, had very grave concern that he would lose consciousness, that there would be another hit and he would be completely vulnerable. And then you entered the gun into the picture, and whether the gun was also then available to Trayvon Martin. The case is controversial. It's been, 12 years now, or almost that long, and it's still always mentioned in the news articles when there's a controversial self-defense case. But,
yeah,
but while Trayvon Martin was unarmed, it was a very different assessment, it looks like to me, than this case will be.
yeah. Well, and I guess I brought that up because I think this guy had people around him who were actually helping him, and it seems like in less time he went to his firearm. And that's where we come up with this idea of the armed defender's dilemma, when uh, and it's most common when you have an armed defender dealing with an unarmed attacker. And then you have this idea of disparity of force. And Steve, to your point,
yeah, he could get in there if he wanted to and start gouging eyes out and really cause some damage. And I think it's tough for an armed defender who's been tackled to the ground wrestling with somebody to know, when does this thing go out of control and when do I have justification to go to my firearm.
Shawn, one of the things I always kind of think about is the self-fulfilling prophecy. And so if I'm going to go to a protest and I feel like my life might be in danger, I need to take a gun. Uh, what do I think the actual physical threat is going to be? And for most people at a protest, it's not going to be another person with a gun. It's going to be people descending upon you and beating you half to death. Therefore, a single individual comes running at you and you're like going, oh my gosh, here it is. This is why I brought my gun. I think it might make it a little bit easier for people to jump to conclusions and use something like that before it's warranted.
That's interesting. Tell me more about this idea. I kind of struggle with this, and I think some of our listeners might too, right? So, uh, we clearly support the right to bear arms. This guy had a carry permit. He had the right to carry a firearm for the purposes of self-defense, but also that comes with responsibility, right? But he also has a First Amendment right. We were talking about a case not long ago where the First Amendment right and the Second Amendment right were overlapping, and I think a lot of people would argue that's there's a reason for that, right? So if you're an armed defender and you decide that you're going to go to a demonstration, and I think there's always a possibility at a demonstration that things could get out of hand. So you're putting yourself in increased risk. Now, a straight reading of our no nonsense, common sense armed defender's handbook would be, don't go to a place where you anticipate violence. If it's not safe to go there, you always say this, Steve, without a gun, it's not safe to go there with a gun. And when I first encountered this case, I thought, okay, well, it seemed like this guy was just there to lend his support. It wasn't clear that he had been harassing people online or going to these all the time. And if you're a concealed carrier and you want to go to what you think is going to be a peaceful demonstration, and you're in the practice and habit of carrying responsibly, are you irresponsible to take the gun at that point? And then what's that fine line between, oh, I kind of took the gun, maybe looking for some trouble?
Well, I just kind of always think about this, maybe it's a little bit like the Daniel Perry case in Austin,
Yeah, there's a
where
lot of
he said,
parallels.
okay, I may need to use a gun. I think you see this in some of the cases that we've discussed that involved uh, a home intrusion when perhaps a armed homeowner felt like if somebody breaks into my house, I have the right to shoot them. I'm going to shoot them. And then when something like that actually takes place, they do, only to find out that perhaps that person really did not have, bad intent. I think we can kind of lull ourselves into thinking that I've got this particular weapon protect me against this particular event. And if I see something that resembles that event, then I might be more prone towards responding to it with violence.
Do you think, Steve, there's actually a mindset that you have to sort of retool when you decide to insert yourself in one of these things that you know has the potential to get hostile and maybe even physical, but not necessarily deadly? It would be the extraordinary situation where it actually became deadly, but not extraordinary when there are fights that break out or people face off against each other and say ugly things that you would never let slide. And that while you may have the right to go there with a gun, it may be smart in your own self-protection to have a gun. The threshold or the level that you might decide to go to it is different. Maybe it's a different calculation, different assessment. And when you know that you have a greater likelihood of being physically challenged, you have to, my sense of it, my just common sense seems to be, you better be even smarter about when you display or use the firearm.
You have to set that bar higher.
Mm-hmm.
And you've got to make a commitment before the fact that it's going to take something this serious. I'm going to have to absolutely know that my life is in imminent danger right now. And if I don't respond right now, I'm going to be killed before I'm going to bring a gun to bear. Which also means that if you see anything less than that, then that is a clue to you to probably take an action that maybe will make it less likely to happen. That is, okay, I'm going to create distance. I'm going to leave. I'm going to get in a position where I'm behind cover so I can kind of watch. But you really just have to rethink. You just have to make decisions on how you're going to conduct yourself for the rest of your life anytime that you're armed.
So let me point out a couple of things that struck me as a criminal defense lawyer, because it was obvious when you see the video that the fellow Caleb Gannon, we'll make him the initial aggressor, saying he had no legal right to run across the street and tackle Scott Hayes. So he commits the first crime, we'll say, which means that, and it was ongoing. It wasn't a one and done. It wasn't like Scott Hayes then chased him to get retribution for being hit. It was ongoing. It was on at that point. So clearly, Scott Hayes had the right to act in self defense to prevent himself from being injured or attacked further. So it's not a question of who is involved. We know because self defense is yes, I did it. In fact, Scott Hayes would quickly admit that he is the one who fired the gun. The problem is, and I think what this illustrates is, we talk about Andrew Branca's 5 elements of self defense, and what we don't often talk about is typically it's pretty obvious to the trained eye that it's not going to be all of the elements that are a problem. It's really the whole case is going to boil down to one or two, and probably one, and it's going to be obvious pretty quickly what is the element that's going to be the tricky one in the case. Because if you look at the other side of that, the prosecutor has to disprove self-defense beyond a reasonable doubt, but they only have to disprove one of them. So you have the right to defend yourself. You didn't start the fight. You couldn't avoid it, or you did if you had the legal right to. In this case, though, it's going to talk about proportionality and disproportional force. And everybody knows that, I think, now. And the question is, no matter how right Scott Hayes was to defend himself, the prosecutor, if they can convince the jury that it's not reasonable. It's not reasonable in the totality of the circumstances that he faced an imminent threat of great bodily harm or death, an imminent threat of harm, yes, physical contact, yes, maybe even some injury, yes, but it wasn't an imminent threat of great bodily harm or death. And while he had the legal right to defend himself, he did not have the legal right to effectively take someone's life or use deadly force, which could take someone's life. And that means if the jury buys that, no matter how sympathetic they may be to Scott Hayes at the time, they can simply say that self-defense was disproven because the force used was disproportional to the force threatened. And what that means is he gets convicted. And he gets convicted even though he clearly has the right to defend himself to a degree. And he's charged with assault and battery with a dangerous weapon, I think is the actual charge he has that's still floating around. And that carries up to 10 years in prison. So the whole analysis could boil down to whether the jury thinks it was reasonable under all of that stuff that was going on, that he had a reasonable enough fear that he could pull the trigger. And they could say, no, if you're going to go to one of these things and you're going to engage people and you're going to taunt people and provoke people and bump people, you're going to have to be willing to take a punch or two before you can go to the gun.
And that's just it. So I think when people are making that assessment, depending upon what they know about you, might affect how they judge you in there. And so if it were, we did the Curtis Reeves case, and he was a man in his 70s who was being attacked by a guy in his 40s. and he was just not as capable physically to fight back, and he made some very bad mistakes, but the jury seemed to feel a little sorry for him and gave him a break and acquitted him,
Yeah, the
right?
popcorn case, the popcorn
Yeah,
movie
popcorn
case.
case.
Hmm.
Yeah, yeah. And so in this case, I think it's so. If you look at the video, this guy was crazed, running across the street, and just tackles this guy and is not letting up. I think that Sky Hayes is capable of receiving the jury's sympathy, and for them forgiving him for maybe misjudging the situation, except for these other kickers that you threw in here, which is, I'm sure, I don't know what the jury's going to be able to see about his social media posts, but there are witnesses that are going to be presented. I know the state's definitely going to try to get it in,
Hmm.
that picture of the gun, and say, bring it, and testimony that he was known to bump, and let's stop right there too, because people might not realize this, but really any intentional unwanted contact could be construed as assault. I was on a misdemeanor defense case one time because a guy spit at someone, allegedly. That's not proven that he spit, and then just bumped his shoulder into him passing by, and all of a sudden we're trying to defend this guy in a misdemeanor. So if they're going to be unsympathetic to that behavior, and that can be enough to cause him to lose any grace that jury might be otherwise inclined to give him.
Yeah, he doesn't have the clean hands. I guess that's what we kind of talk sometimes about. Your client has clean hands, or the witness has clean hands, meaning they don't have this baggage, they don't have a history of stuff, and they haven't done anything to make their situation worse. So, yeah, I think that we started the podcast by talking about some of the stuff that Hayes had done. It was sort of the cart before the horse. But now that we've talked about that moment in time, when we talk about self defense cases, the incident itself is typically just seconds. It would be an
Yeah.
extremely long self defense case if it lasted more than, what, 30 seconds, Steve? A minute, even if it's a physical fight, frankly.
I mean, it's a long time in a fight.
So what happens now, this case, just like so many others, is going to get expanded. It's going to get expanded to the stuff he did before, the stuff he did after. They're going to do a deep dive into this fella, Caleb Gannon, see if he has a prior criminal history, and start really digging into this to try to gain an advantage in the case. But notwithstanding the social protests in support of Scott Hayes, he's now charged. He has no control over that. He's got lawyers fighting for him, and they'll hopefully do a really good job. But he has completely lost control of his life now until this criminal case is over. Whether the judge would give him a prison sentence at the end of the day, that's up to the judge. Hayes has no control over that either, but certainly the judge has um, plenty of rope if he wants it, up to 10 years if he's convicted of these charges. So it's not nothing, it's real.
Yeah, and he was able to post a $5,000 bond, uh, and that is because he didn't kill that guy, and I think he's lucky that he didn't kill him. Not as lucky as the other guy is that he didn't get killed, but
Mm-hmm.
it could have just as easily been a fatal shot, and now $5,000 isn't going to cut it
Yeah,
because you get bombed in the
it's
wall.
not assault and battery with a dangerous weapon at that point, is it? It's some degree of manslaughter, maybe even a lower level of murder at that point, and bails are commensurate with it. We've all seen bails in the work that we do that are in
Yeah,
excess of $1 million.
Steve, I think it's worth. I don't. I think it's worth. I know you spent some time on some forums and different internet stuff where people post braggadocious memes about firearms. We've talked about it before, but as the guy here on this call who's got the most cred and the most interaction with um, people in a tactical environment using the tool, talking about the tool, Just tell them again about posting on social media, would you, Steve?
Yeah, it's some people just don't want to hear it. They don't want to hear it. And then, hopefully they never have to deal with it. But boy, I would hate to have put some of that stuff out on Facebook and then for the rest of my life know that if I get involved in an altercation at some point, that's going to come up during my trial. That's pretty scary to me.
And in this case, I think it'd be particularly tough to swallow because I know we don't know exactly what words were exchanged. I read at least one article, maybe a Fox News article, that suggested that the protester yelled first. He said, "You guys are sick, you're sick," and then someone yelled back. It wasn't Scott, and then he yelled back. Scott Hayes may not have even been involved in this verbal altercation, and he, it seems like, maybe did nothing at all to provoke this guy into attacking him in this particular instance. But now he's going to have to contend with uh, evidence that he has had provocative behavior in the past. And while that may not be directly relevant to this particular scenario, a good prosecutor might argue that that informs that he had the mindset of a provocateur, and that could really cause further damage to his case.
Isn't this classic? A guy looking for trouble. If you put all of that stuff together, that he's going to have to explain away. That's what the prosecutor. That's how they're going to want to paint him.
Yeah.
Here's a guy inserting himself in what he knows are volatile and really, really emotional situations where people are losing tempers. They're losing rational thought, and putting himself in a situation where he is more likely to be a target of that hostility, and he puts a gun in his pocket and goes there to meet the challenge. And now there's this picture out there where what a heyday or field day that the prosecutor is going to have with that single image of this. I think it was a tan colored gun with the red dot and the flashlight and the sort of the dog tag thing with the Star of David. And that's not enough. He had to say, "Hey, Jew haters." So he's targeting a very specific audience with his post, people that he is insulting by calling them Jew haters, which I'm assuming he is labeling people that are demonstrating for Gaza. That's the other side of this protest, counter-protest stuff. And then he didn't even stop there. He said, "Bring it." So bring it. What does that mean to anybody? It means try me. Go ahead. Take your chances. Come on. I'm ready for you, which is textbook provocation, frankly.
Yeah.
And then, I mean, just another example of a guy digging a big hole before he ever gets out of bed.
Yeah. And like Steve was saying, if you have provocative language and it looks like you're going out looking for trouble, even if you're not looking for trouble and trouble finds you, you're going to be held responsible for what you said before, and it gets skewed in the juror's mind. I will tell you, though, at our house, the term "bring it" usually is an invitation for a guest to bring dessert and a bottle of wine. So.
I might take that challenge.
All right, everybody, that's the podcast today. I appreciate you listening through to the end. I've got a couple podcasts coming up that is about how an armed offender is responsible for every bullet they fire in self-defense. Sometimes that can result in unintended tragedies. Check back with us soon. Until then, as always, be smart, stay safe, take care.
You're going to have to be willing to take a punch or two before you can go to the gun.